Good afternoon to you all. I'm called Christina Awori, the CEO of Uganda Law Society. And I'm here in that capacity to welcome you all. I welcome all the members of Uganda Law Society present here, members online, the staff of Uganda Law Society, the public online, the council members present, both online and present here physically, and our two guest speakers today. We have Advocate Musisi George, and we also have Advocate Jude Byabakama. You're welcome to our weekly Radical New Bar Live press and public engagement. This is the 7th series, and we are going to, Council Musisi is going to speak about grievances and concerns, and he will tell us from where he's coming from to speak to us about those concerns and grievances. Then we have Councillor Jude, who is going to give us an update on the cases in court. Councillor Jude is the one who represents Uganda Law Society, all the cases that have been happening in Uganda Law Society since November last year, and assisted by our own Councillor Mariam Nansuksa of Legal Aid. Councillor Nansuksa will not speak today, but Councillor Jude will speak to us. You are all welcome. Thank you. I take this opportunity right away to invite Advocate Musisi George to come and take up the podium and address us. Thank you.
Thank you, Madam CEO. Good afternoon, ladies and gentlemen. The Vice President, members of Uganda Law Society, council members present, our colleagues from the media, ladies and gentlemen. My name is George Musisi, as Christine has rightly introduced me, and I represent the National Unity Platform as a legal advisor, counsel, as a legal representative in many matters. I was asked to speak to some of the issues pertaining, and I will restrict myself to the legal issues. And we know that the National Unity Platform has made news for the last 1 week, but I want to stretch it to the last 10 days. If you discount the events that happened yesterday when our candidate for the Kawempe North by-election was being registered, by yesterday we had 10 people, that was before yesterday, abducted by security agencies. I deliberately use the words abduction to the chagrin of the government spokesperson, Honorable Chris Barriomos, who has told me several not to use abducted, because I know an arrest is defined under our laws. And we know that even our constitution lists down the pre-trial rights, the procedural steps to take when a person is being arrested. Very basically, you are supposed to tell me why you are detaining me. You are supposed to tell me the charge. You are supposed to take me to a gazetted place. You are supposed to allow me access to next of kin or lawyer or even medical services of my choice. All that, those are constitutional rights. And if at all you are to detain me, you are not supposed to detain me for more than 24 hours. You are supposed to produce me before a court of law. Where people dressed like my brother Adam here, but armed, these days also masked, come and arrest me in an unregistered car, take me to an unknown place, don't tell me why I'm being held for several days, that cannot be defined as an arrest. So those are state-sponsored abductions. So we've had 10 people abducted in the last 10 days. Only 3 of them were only yesterday charged formally before the Chief Magistrate's Court of Masaka with aggravated robbery. Even these 3, I had a chance, they were arrested on last week on Thursday and kept in a gazetted place at CPS, Central Police Station, Kampala. And even when I met them on Monday, I was told the charge was something to do with unlawful drilling. Until they were driven that afternoon to Masaka and were charged with aggravated robbery of events which purported to have happened sometime in May last year. But at least now they are charged and they're in a known place. The other 7 have all been released. Well, of course, we had filed for habeas corpus applications for all of them. And the first application to came up on Monday this week before the High Court. And the state asked for 1 more day to consult its state agencies, and then they were all released. And the release itself was by the same security who have been holding them, driving them to a police station and telling them, you go home. Out of the 7, only 2 were given bond papers. Others were just released, that you just go home. Actually, one of them was not even dropped at a police station. One of them was just dropped at a place about 100 meters away from his home. But all these were in state detention. All of them were in the custody of what used to be called at CMI. I know it has a very lengthy name now, but the same premises. And of course, all of them bear the same story, that we are taken, hooded, detained, tortured, beaten. Of course, the torture is now through beatings. But I want to relate the last 10 events to what has been happening the last almost 4 years. Many times we want to leave a record. So we've been to the High Court. We've filed over 50 habeas corpus applications before the High Court in the last 5 years. All those things they called for the drone attacks. And the standard has been the same, that we either, sometimes they would even first hold you for a month. If we don't go to court, they don't release. Until when the matter is coming up, or when the court is very angry towards the state attorney, and the state attorney makes the relevant calls, and then they are released just to defeat, or they are charged. Very few have been charged. Most of them have been released without charge. So it's an abuse as well, and this is where I would call upon courts, because the laws are very extensive, and like it happened in the case of Dr. Kiza Besigye. It's not enough for you to say that now the person is here. Now the habeas corpus has been overtaken. I think court has a duty to interrogate this detention and make other orders. Yes, you've now released him, but in which custody has he been in for the last 1 month or for the last 10 days? And that's a chance we always lose from courts. Because even the Dr. Kiza Besigye case, I felt that court should have pronounced itself on the legality of the detention between 3rd, when the warrant expired, to the day when he was produced in court. So, because as it is now, it doesn't send a deterrent message to these agencies. First of all, these people are lucky that they have a lawyer who will go to court and file an habeas. It means that if there's no lawyer filing habeas corpus for you, you can remain there. And indeed, there are stories of people who have remained there. It also took us to the issue of the siege, abductions aside, or raid, which police called a search as well. I also prefer to use my words very deliberately, because a search is a legal issue. Any search of a premise should be, for it to conduct any bit of lawfulness, it should have some minimums. If you are to search, I was talking to the government spokesperson, Honorable Mr. Fonopondo, on Saturday, and he told me that he has information that they had an ex parte warrant from court, which has not been availed to anyone till today. But even if they did, for an institution, even for Isiko's home or Munabi's home, it doesn't hurt for you to knock on my gate and say, we are here to search you. So stay as you are and we conduct the search. But for you to chase out everyone, switch off power, disconnect CCTV, I made a tweet on X that if a premise has CCTV footage, like NOOP offices have, every room has CCTV camera. It's in your interest that you leave the CCTV on, such that you recover these items when the CCTV is recording. It's in government interest. The only reason you'd switch off CCTV is to see that whatever you're conducting is outside the realms of the law. So no one was there, no official was there, even for a party which has representation, legal lawyers and non-leadership. That's why you see doors being broken into. That's why you see the items recovered. Of course, no one could tell, no one signed the search certificate. And police came up to, like to sanitize, to say, exhibits were recovered. We all saw the statement from police saying, exhibits were recovered which will be used in evidence. I leave that to lawyers to know whether those, whatever they recover there has an evidential value. But what I can assert is that the search, the raid, the siege flouted minimum standards of a security agency search, and we've taken the decision, we've been instructed to go to court to proceed against not only the Attorney General, but the commanders who commanded the search and those who have command responsibility over the forces which were there. That is the army and police. And of course, on top of that unlawful raid, they also committed acts of burglary because they carried different issues that, of course, police have not given us the advantage of knowing what was recovered or not. But we strongly believe that they were taken with malice, including money, including clothes, but all that will be seen. What I want to conclude with is the legal response. If I connect, especially the abductions, because at least, and of course even the search itself and the raid, it's not the first time it's happening to NOOP. It happened in 2021, only that then it was actually a siege. They stayed for about 3 weeks. We had to go to court. When the day the case was coming up before the High Court, they left the previous night in order to defeat. And of course, High Court said, okay, since it has been overtaken by events, we can now have the matter withdrawn. It happened to FDC in 2011. I remember it was also siege. I think it took about 3 weeks when they occupied the Najanakombi offices. So is from the time of filing, which in itself has a purpose of defeating the application. We've brought up human rights enforcement matters. When these laws were enacted, the Prohibition and Prevention of Torture Act and the Human Rights Enforcement Act, I was one of those people who was very delighted. We thought it was a new turn in terms of human rights enforcement and respect by agencies. But years down the road, I don't think that they've been given their whole gist. We have over 10 human rights enforcement matters. With me, I carried my client, Samuel Masereka, here. Sam, if you could join me here, maybe very briefly. Sam was a member of NOOP, a registrar in Kasese, and he was abducted by those drones in the late 2021, in December, and held at CMI for over a month, incommunicado, badly tortured. Many of you who are following the remarks would have seen he's now a law student. He was inspired to do law as a result of the torture he faced. Maybe that was the silver lining on that. He was a medic, he changed to law, he's a second-year law student. But Sam was badly tortured. Those of you who saw him in 2022 wouldn't tell the man. He had bad torture marks. And we filed the matter in 2022, January. Sam, you could take your seat. And it was hard. It's only this year, about 2 weeks ago, that we received judgment in a decision where he was given 30 million, which is also paltry. Because the issue, we had even gone against the boss of CMI then, General Kandiho, and court, of course, chose not to pronounce itself on the matter because it sued 2 respondents. Court only awarded against the Attorney General. But most importantly, that the law envisaged that these human rights matters would be handled expeditiously. Some of the judgments we've received, including Honorable Zake, he hasn't been awarded his little money. But then, leave alone this one, some now has taken 3 years to get judgment. We have matters which have taken 2 years without being heard for the first time. 2 of them, people, our clients, allege that they were raped in custody while in military detention. But these cases and of course there's even medical evidence to back up those claims, and these matters are before the High Court, are lying before the High Court, and they have not been heard for 2 years. So we don't even know when the judgment will come, because 2 years have not been heard. And the law envisaged that in 1 year this case will be heard, completed, and let alone. So this calls to us issues of how responsive is the law towards some of those abductions. And of course, lastly, attendant to the abductions is the issue of missing persons. We have 18 people who are still missing. They were taken variously from 2020 and 2021, especially after November 2020. We filed a case before the High Court, and the High Court, that one, I think it was expeditiously heard, because we filed it, and from the date of filing to the date of judgment, it was about 10 months in between. So the High Court expeditiously heard and dismissed, and said that on the ground that these people, the deponents of the affidavits, the relatives, some of them who saw and had not convinced court that these people were indeed in government custody. However, all these people were taken in similar circumstances, just like you saw those who have been captured on camera, just like you saw our colleague Nalukola was taken yesterday. Of course, those ones who took Nalukola, some of them had some marks which had judged, but many times they don't have. They're dressed like in civilian wear, and sometimes even the cars are not. And one time I challenged the Uganda Human Rights Commission because I'd laid. You remember the case of Eric Mwesigwa, who was burnt with marks all over his chest. And when we were filing the matter in the Human Rights Commission, I challenged those lawyers. I said that you have a mandate. This man claims to have been picked from the streets of Kampala. He was dropped from the streets of Kampala, which have CCTV. Liaise with Uganda police to give you footage, and it's so easy to verify because the date is known, when he was picked, the time is known, and when he was dropped. And of course, that's where it ended. So the responsiveness of the institutions, including UHRC, of course for UHRC we decided to keep praying for it. But courts, because of course we envisaged that UHRC would be, being a tribunal, would be quicker to dispose of these human rights matters. But if courts are even quicker, which are already backlogged, are quicker than UHRC, it's an indictment. But the responsiveness, they have that the institutions are slow to respond, has acted as a tacit condonation to the people who are committing those acts, that they can continue and nothing will happen. Ladies and gentlemen, I request to end here. I will take any questions if there are at all. But the last message is, I always say, there is no person who should be above the law. And we are not saying that people of this particular color shouldn't be charged. We can only pray that every person, irrespective of political color, should be treated as the law says. It's just the basic minimum of a decent society that we all aspire for. I thank you for listening to me. The CEO has requested, of course, if it was Vice President Anton, I would have said she has ordered, but the CEO has requested that I give a brief in Luganda. So I'll give a brief. Ennaku eziise 10 ekibiina kya National Unity Platform kibadde n'ensonga ze tulowooza nti ng'oggyeko ebyobufuzi eby'amateeka byo byandibadde bitugatta ffenna. Tubadde n'abantu abawambiddwa nga era ennaku eziise 10 abantu abawere 10 bawambiddwa. Bwe tugamba okuwambibwa kitegeeza nti bakwatiddwa mu ngeri eteri amateeka gye galagira. Okukwata amateeka gakirungamya nti olina kukwatibwa bw'oti n'oteekebwa mu kaduukulu akamanyikiddwa. Bw'oba oyagala okubuuza kuba oba olina balooya bo, oba olina mukyalawo, mugambe nti ndi ku poliisi eno bankutira musango bwe guti, bantwale mu kkooti mu nnaku ezisasuka 2. Naye ababadde bakwatibwa bano bakwatibwa nga abantu bali mu leeya, bakuumibwa mu bifo ebitamanyiddwa, ne basiiba nga bakubibwa emiggo, ne bateebwa. Abantu 10 abakwatiddwa 3 bokka be bavunaaniddwa mu mbuga z'amateeka, era bavunaaniddwa jjo mu kkooti y'e Masaka. Ate nga ne bano basooka omu bamutwala newuwe ne bakola okwaza era ka search statement bakapapula ke bajjayo bateekako nti banoonyereza omusango bayita unlawful drilling naye ate we bagenza omuvunana bamuvunanye nti awe Masaka wakuba omuntu n'omubbako akasimu mu mwezi gw'okutaano omwaka oguwedde kaakati ate akasimu ne unlawful drilling byali bikwataganirawa so kirabika nti basooka kukukwata ne balyoka banoonya musango kyo gukukwata naye at least bo bano tumanyi gye bali lwakiri naye omusanvu bakumibwa mu kaduukulu nga bakubibwa era oluvannyuma bonna ne bateebwa nga tebaguddwako na musango ate nga bateebwa mu ngeri gy'olowooza nti yandibadde eringa abantu bano abawamba abantu kubanga omu baamusuula ku kkubo abalala babatwala ne bavuga ku poliisi ne babagamba ti mugende kati mugende wammwe tubatadde naye nga bakumiddwa abamu wiiki 2 abamu nnaku 5 nga balina n'ebisago ate nga kiraga nti babadde emikono gya gavumenti so ekyo ne kigamba nti kigatta ku bintu ze tulaba emabega emyaka egiyise ena tubadde mu kooti enfunda eziwera 50 gino misango gya njawulo nga tusaba ekiragiro ekyo ekigamba nti gavumenti muleete omuntu waffe oba mufu oba mulamu ebiragiro ebyo ebisinga tugenda mu kooti ng'omuntu abuze tetutera kugenda nga mu nnaku 3 tutera kugenda nga wayisewo wiiki ng'emu ng'oba 2 kaakati ate bo kye bakola kasita bamanya nti omusango gujja olwaleero nga bamuta bwe bamanya nti kooti ekandaludde ku ddoboozi nga bamuta era ekyo ne tugamba nti kooti nazo zandibadde ziyize kaakati nti abantu bano okusindika akabonero nti okuwambibwa tekukkirizibwa mu Uganda kooti zirina obuyinza bw'amaanyi nnyo sigamba bugambi nti kaakati tumutadde kiringa ekitegeeza nti bwenkwata omuntu nemukwata nemukuba nemukuumira eyo bwe ndaba nga munkutte nga kale mutadde genda zandibadde ziwa n'ebibonerezo ku kiseera kino kyabadde mu nkomyo obusibe buno obadde bwa kikula ki nga bwe twalaba ku musango gwa Dr. Kizza Besigye kubanga okuva nga 3 paka we yali simbiddwa mu kooti olwokutaano luwedde Nakawa abadde mu busibe bwa kikaaki bw'aba tabadde mu mateeka okyogerako kyekyo kubanga institutions za government zino obuvunaanyizibwa mu ssemateeka okulaba nga zigondera era zikuuma era zissa ekitiibwa mu ddembe ly'obuntu kaakati bw'oba ogamba nti institution ya government esobola okuwamba omuntu then we bagikwata negamba kale mutadde osindika kabonero okiggwe nga kooti eri abantu abayisa bwe batyo era abantu b'ekikula bwe kityo twogedde ne ku nsonga okuwambibwa okulumbibwa gw'ekitebe abapoliisi bafulumya ekiwandiiko ne bagamba nti baali bakola okwaza tukimanyi kituufu poliisi erina obuvunaanyizibwa mu mateeka okwaza ekifo kyonna naye bw'oba ogenda okwaza ne bw'oba olina olukusa okuva mu kooti lwe tutannalabako okuva otuusa olwaleero nga omuntu alina amaka agamanyikiddwa oba ekitongole kirina obukulembeze obumanyikiddwa ne bannamateeka etteeka kigamba nti balina okubeerawo ng'oyaza by'osobola okugjayo obikozese nga tebabyegaana mu kooti naye bw'ojja nga n'obagobawo n'osalako amasannyalaze n'osalako kamera bw'ebanga kamera buli kisenge kyonna ku office NUP kirimu kamera naye lwaki muziggyako ate nga mugamba nti mwaza kubanga kyandibadde kiyamba poliisi bajje ebintu bino byakukulidde bye bagamba nga ne kamera za NUP zennyini ziraba era bandigambye bugambi kamera zaabwe zizino buli kimu twakijjayo naye baazimenya enzigi bamenyamenye ekiraga nti bayingira tebali bokka ne boonona n'ebintu ebirala so ebyo bye bakola byonna tebiri mu mateeka ekiwandiiko kya poliisi kyagamba mbu ebizibiti birina engeri gye bikwatibwamu mu mateeka birina engeri gye bijjibwa ku scene oba ewaddiziddwa omusango era byonna bye baamenya so twalagiddwa nga bannamateeka okuggula omusango ku gavumenti ne ba officers abaakola ebintu bino era ndowooza mu nnaku ezitali zawala mujja kugulaba mu kooti enkulu nga guguddwawo kubanga mwalimu n'obubbi n'okwonoona ebintu okwekigenderere kati tuwumbye nga tugamba nti ebitongole birina okulwanira eddembe ly'obuntu ne courts bikoze ekimala okuwulira ensonga zino kubanga twafuna etteeka erikwata ku kulwanyisa oba okulwanirira eddembe ly'obuntu ng'etteeka ligamba nti ensonga zino ez'eddembe ly'obuntu zirina kuwulirwa mu mwaka nga gumu kubanga omuntu aba agamba nti bankuba nemadde sisobola kukola n'otwala emyaka 3 nga n'omusango tonnaba naguwulira kuva n'okugusala naye tonnaba naguwulira naawe obanga yeegasse ku kulityoboola tumanye ebizibu byaffe n'akakiiko eddembe ly'obuntu kubanga twali tugamba nti akakiiko eddembe ly'obuntu nga tribunal yes tukimanyi tikalina ssente naye bw'otwalayo omusango ne gumala emyaka 5 nga musango kubanga abantu bano baba banoonya compensation kuliyirirwa nti bankuba sikyasobola kukola n'emyaka 5 towuliddwa olwo oba ogenda kungasa ki In fact emisango egimu egiri mu kooti tegyandibadde senga Human Rights Commission badde ekola ku speed. Naye ne kooti zennyini zikola mpola emisango gino egimu gyandibadde gisoosowazibwa. Kubanga tulina emisango abantu abamu nga bagamba bakwatibwa n'okukwatibwa mu buduukulu. Emisango egyo gimaze emyaka 2 tegina na kuwulirwa. Tubalaze Saamu oyo yawambibwa abadrone abo n'akubibwa n'ayisibwa bubi nnyo yamalayo yo mwezi mulamba mu kaduukulu ako aka safe house. Era n'avaayo nga tasobola na kutambula. Senga olaba ebifaananyi bye kaakati tuyinza mmutegeera. Naye ne tugenda mu kooti January 2022 omusango twagufunye ensala twagifunye 2025. Ate eyo kakati eriyo abatannaba kuwulirwa myaka 2. Ate ng'eyo nsala di sabawolereza wa gavumenti wanamusasulira ekyo tutumanyi. Naye eriyo mingi emirala gye tulowooza nti gyandibadde gisoosowazibwa kubanga abantu kakati abamu tebasobola na kukola olw'obuvune obwabatuusibwako. Naye n'ekirala nti olina okusindika message eri bano abatyobola eddembe ly'obuntu. Bwe babeera nga tewaliwo ddoboozi kakaliri bagambako kuva mu kooti kitegeeza tebagisigala nga bakikola kubanga amateeka ago gagamba abantu oyinza n'obbavunaana bo mu mannya gaabwe nti order from above tebikola. Naye lwaki tulina amateeka amalungi bwe gatyo ate nga n'ebikolwa ebityobola eddembe ly'obuntu byeyongera? Kitegeeza nti amateeka tegayambye nnyo kuuma ddembe eyo. Mmaliriza nga njogera ne ku nsonga ya abantu abaabula ne 18 omusango twagutwala mu kooti enkulu omwaka oguwedde. Era ngambye nti obutafaanako nga gino emirala gogwo guno gwayanguwa era kooti tugyebaza yakola speed n'egugoba kuba gwawulirizibwa mu myezi nga 10 nga guwedde. Era twajulira twateekayo okujulira mu kooti ejulirwamu nga tulowooza nti omulamuzi okugamba abantu bano abalaba abantu babe nga bakwatibwa abantu abali mu leeya n'obagamba nti ate be balina obuvunaanyizibwa okulaga nti bali mu mikono gya gavumenti oba bataddeko burden eya waggulu ennyo. Kubanga ekisooka ng'oggyeko poliisi yeyingiza mu bitabo. Naye abantu bano bonna nga bano be tubagambye ababadde bano bamasereka bano banyanzi be batadde last week Rashidi Kinobe tebabeera mu buduukulu bwa poliisi. Kitegeeza tewaliwo kitabo kyonna kyojja kuleeta kigambe nti twamuyingiza mu entry book. Babeera mu buduukulu obutamanyikiddwa obutali gazetted mu mateeka oba obutakkirizibwa. N'olwekyo ne tulowooza nti bwe tunaagenda mu maaso ga kooti ejulirwamu tujja sobola okulaba kubanga abantu bano tebamanyikiddwa gye bali. Famire zaabwe zibanoonya abakyala baabwe bali temuli mu mukyala fortunately so bonna basajja abaabulawo era nga tulowooza nti kooti ejulirwamu yo eneesobola okukaka gavumenti okuwayo abantu abo. Neeyanziza nnyo okumpuliriza. Waliwo wa Radio West njogere mu Lunyankole?
Some questions are welcome.
Neeyanziza nnyo mukulu Musisi era mukaaga akongenda tandika na Luganda. Amanya nze Munabi Philip, sekretary w'ekibiina ky'abalooya mu Uganda. Nga oggyeko kansooka okutuusa okusasira kwange eri munnaffe Nalukoola ku byamutuusiddwako kuba ekibuuzo kyange kigenda kubeera wakati kwekyo ekyabaddewo. Nga oggyeko okugenda mu kkooti kwebyo ebyaliwo ebyokulumba ofiisi zammwe oba n'abantu bannayuganda balala bazze ensonga bwe zito zibabaako. Kuyita kikwolina oba bubaka kibwoweereza eri ebitongole ebikwatibwa ku nsonga zino nga Electoral Commission, Uganda Law Society wano nayo evunaanyizibwa okuwabula gavumenti naddala ku nsonga y'akalulu ke tugendamu mu 2026. Ekyatuusiddwa ku mukwano gwaffe oba munnaffe Nalukoola kiraga nti omuntu bw'amala okunominatinga alina kwekweka mu kaabuyonjo za Electoral Commission oba nayeesiba masiki nadde ewaka. Kuba omusajja yagenze n'awaayo empapula ze bulungi naye nga tannawaayo na mpapula wabaddewo ebimutuusibwako. Bwe yamaze okuwaayo empapula ze ne wabeerawo embeera enkyamu ennyo. Bubaka ki mu ndowooza yo tosuubira nti wandibadde tubeere n'okulambululwa nti womala okunominatinga naddala mu kalulu akajja kuba gye kiraga eno yabadde just by election naye mu kalulu akajja ogenda kulaba embeera bwetyo. So singa tutandika kati gwe tosuubira nti kirungi tubeere n'amateeka oba okulambululwa eri bannayuganda bagenda okwetaba mu kalulu ab'ebibiina eby'enjawulo kuba ebigoberedde by election y'e Kawempe bijja kulaga nti forces zijja kujja mu Uganda Law Society kuba nammwe muwabula gavumenti ziwambe ekizimbe kyonna age tulina bye tunoonya kubanga mwawabulako gavumenti ku bintu bya kalulu. So kyekibuuzo kyange oba yendowooza yange njagala nfuna ebirowoozo byo gyekiri. My name is Philip Munabi, kuba 40. My name is Philip Munabi. Thank you for the update. I wish to send my regards and message of hope to my candidate. He's my candidate in Kawempe North, Councillor Nalukola. Sorry for what happened to him. But my question is, what is your call to the bodies beyond taking action in courts of law? What is your call more so in reflection to the upcoming general election? Because what happened to Councillor Nalukola was an instance that showed after nominating, you simply need to hide or find a clandestine NUP muchita rabadab. You have to move out rabadab, which is not the case. So should the entities and stakeholders concerned advise the bodies that have authority in these general elections, more so electoral commission, to have regulations on how to have peace and harmony in the next election? Thank you.
Thank you so much. Any other questions? Those online were also requested to post a message in form of question. Are there any that are physical? If there are no, I would request that you can address that. Thank you.
Thank you, Philip. My message to Uganda Law Society, to civil society, one of the problems, many times, so those of you who are ardent social media users, and I've faced this criticism from President Semakade and even Jude on some occasions, that nope, you're not doing enough, nope, you're not doing this. My problem is that there's a lot of, and I'm not trying to shield that from criticism, but because of the almost near death of the civil society, almost all the torch and burden is on the opposition. Because previously, if you remember the last 2006 elections, we even had civil society offices broken into because civil society groups had done monitoring of elections that documented. You hardly hear that anymore. We had break-ins. I remember FHRA was broken into. I remember we had break-ins of offices, about 2-3 civil society organizations, which were involved in elections. And the same thing happened in 2011. Now, the challenge is, and I remember even 2 days ago, there was a sermon at Namirembe Cathedral, where a retired clergy was urging church that please speak out. With the greatest of respect, when Kakwenza was beaten, I remember, I think it was Aaron, I'm on the UCLF forum, I'm a member of UCLF. I remember Aaron sharing pictures of Kakwenza, and there was no comment from anyone. And about 3 hours later, someone shared a biblical verse, and then I saw amens. Amen, amen. And I thought that was the time when Jesus would have cracked the whip. That there are many voices that should be speaking out more often that are apolitical. Because now, when a new person speaks against torture, they will say, what would you have said? Those are new people. It's different, and I've challenged even friends of mine who are priests, starting from some of the highest offices, that we need voices. Of course, civil society, it also has a brick on its neck. That I know that. It has an institutional brick on its neck that some of them can't be as critical as they would have been 10 years ago. Because of the legislative framework, someone tells you there's a very vibrant civil society organization tells us, our permit is expiring soon, so we can't appear anywhere close to you. There is another civil society organization which wanted me to give them some facts. They told me, however, we can't meet at our offices. You can't dare be seen. At least I thank God that I'm still welcome at ULS. But most importantly, that we need as many voices as possible. And the voice of ULS. Of course, even in ULS, I remember, I don't know any of you members who attended the extra, it was an EGM to discuss whether ULS should have a position on the change of term limits in 2017. It was at our old building. And I remember there was a discussion, I think it was called by, among others, Aaron Keys and Daniel Remeda. They had petitioned. So there was a discussion as to whether some members were saying, no, we shouldn't make a position on the constitutional amendments. And I remember someone saying, if lawyers cannot give a position on constitutional amendments, who should? Architects or medical association? So I know that even ULS, we are kind of polarized because of the different, but for some matters, rule of law, we should speak with one voice because the law is clear. And for me, that's also fair people. And some people say, you are an opposition lawyer. I say, okay, I would gladly listen to you tell me, no, that search was within the law because of this and this. Simple as that. So we need more voices. We need private prosecutions of some of these people, some of these characters. And of course, even to EC, and I've even shared my sentiments with the good judge, Justice Byabakama. And I know we disagree in terms of how he perceives the constitutional mandate he has on the management of elections. Because he has told me that, security should have a role, and for me, I see EC, the constitutional requirement that should be in every aspect of management of elections, should be in charge. It's just like if Justice Anthony Asimo was in court. He can tell a court orderly to evict me. But a court orderly cannot say that because I'm security, I am the one who allows access. The judge, as far as the judge is in court, the judge is in charge of court. So that's how I perceive EC role. Just like at a polling station, there's a presiding officer and there's a warder, an orderly. A presiding officer can tell the orderly that take this person away. But the orderly cannot on themselves say who should access the polling station or not. That is what we saw in the last election. Security determining who should campaign, and that's what happened yesterday. So to EC is to be in charge. It's what's that the Constitution provides for, that management of elections should be, the security should play a supportive role to the EC and should work under the direct command and responsibility of the EC. Candidates should be protected by the Electoral Commission because you brought yourself within the ambit of the EC. I thank you.
Thank you. Thank you so much. Any other questions? Yes.
My name is Nabukenya Zaina. I'm an advocate. Well, my question is, you've been talking about voices, and if at all I'm interested in defending some of those people, how do I join your team? That is one. Then the other thing, as you, every one of us knows, our colleague, Council Aaron Kiza he was imprisoned because of defending, as in you as a human rights lawyer, don't you shake sometimes, as in, that is the second one.
Thank you so much. Council. There you go.
Mariam here knows that sometimes I shake, but the question is, if lemons are thrown to you, what do you do? How do you join? Of course, there are many ways of joining. The first one, the easiest and the quickest, is through ULS. Because if you join through the other path of mine, it might be harder for you. But the quickest will be through ULS, legal aid. Actually, many times when you are on human rights defense, our causes will align at some point. For instance, Aaron, you mentioned Aaron. I don't know, Aaron is not, to my knowledge, and I can comfortably say that I'm one of his closest friends, he's not aligned to any political party. But he has been described as an opposition lawyer. I don't know what. I don't know him for being aligned to any, at least publicly, not even privately, as a person who talks to him privately. So the issue is that start from where you are. There are always many avenues of joining. Last year, I saw many people from this office on the front lines, including Vice President Anthony, Secretary Philip, Mariam there. They were on the front lines because these actions are going to be many, and the legalese is going to be stretched out. They are going to be stretched out, I remember. So how, regarding the other issue, aren't you shaken? What choice do I have? What choice do I have? even if I chose to keep in my house and for the next 6 months, actually they will even say that I've eaten money. But at the end of the day, 54 people on the street were shot on the streets of Kampala in November 2020. I'm quoting the government report, which I think has a modest figure. The numbers could have been higher. 54 people were caught, and over 40 of them by allegedly stray bullets. All of them were not lawyers representing opposition people. So my question always is, as human beings, we always fear any discomfort to our convenience. But there's no peace in this convenience, because as we all saw in November 2020, the people who are throwing stones, they don't discriminate. No po NRM. The people who are shooting, they also don't discriminate. So we are in this together. But then again, why are you lawyers in the first place? And I get this, I hear this many times from colleagues say, oh, people, we are praying for you. We are praying for you. I say that, but you are not any safer than me. You who is doing land transactions, and you're not any safer. We're all in the same boat. So the issue is, Jude knows that there's some private group where one of the senior lawyers recently said, when a debate akin to that came up, but we need to go slow. A senior lawyer said that, and he's a very senior lawyer, said that I would rather live as a lion. I would rather die as a lion than live as a dog all my life. But at the end of the day, even us as Christians, we know we are all getting out of this world at some point. And we're not going as Saint Stephen who went alive. I thank you.
Thank you. Thank you so much. Are there any other questions, please? A question?
There is one from my friend, Mr. Olwain.
You've told us that Council, you've told us that you've got instructions from your clients to take on the matter, to drag government to court. Please help and highlight what will be your strong points in challenging the action of government in yesterday's incident, as you take on the Attorney General.
The only strong point is that the raid flaunted all laws. So it was unlawful, and that there were criminal incidents that happened. Under the law, what they call a cause of action is that your right was disturbed by someone and it caused you a loss, and that the person you are suing is responsible. So we strongly believe that there were violations. There were even criminal activities which were done. Like I told you, the search, what they call a search, was not supported by any laws. There was deliberate destruction of property. There was burglary, which is a criminal offense, where someone breaks into a premise with the intention of stealing. And there was loss occasioned to our clients. So that's the only strong point. And there is evidence to that effect, which is being compiled now. And we believe that in not later than 5 days, a suit will be instituted before the High Court of Uganda, where we shall seek reliefs against not only the Attorney General, but against also the commanding officers of the security groups that we are seen, at least visibly seen. Before the media was chased away, at least there were cars with UPDF plates, there were people with police uniforms. At least those two institutions were seen having a presence on the ground.
Thank you. Thank you so much. Any other questions?
Okay, ansabye nziremu ekibuuzo ekyo mu Luganda, omwami ono Siraje angambye badde ntegeeza nti ensonga enkulu etwaza mu kooti nti ebikolwa byonna byali bimenya amateeka. Ebikolwa byonna ebyakolebwa abakuumaddembe koolo, ng'okutandika ku kujja ne muyingirira ofiisi y'omuntu nga temulina lukusa, kubanga olukusa olulambikiddwa amateeka lwandibadde lutambuliza mu mbeera ndala. okumenya, okwonoona ebintu, okubba, ate era nga bikolwa bya bugenderevu. Tulowooza nti byonna byali bikola bimenya amateeka. Era nga tuli mu kukuŋŋaanya bujulizi essaawa zino. Mu nnaku ezisasuka 5 omusango gujja kuba guteereddwayo mu kkooti enkulu gye tujja okuloopa ng'oggyeko ssaabawolereza wa gavumenti naye n'aba officers abamu abaduumira ebitongole ebyalabibwako amagye ne poliisi ebyalabibwako nga bikola ebikolwa ebyo by'obumenyi bw'amateeka. Maybe tulina okumanya nti ne ku mulundi guli we baakikola kyembagambye baavaawo teri muntu yenna yavunaanibwa, baatwala ebintu bingi nnyo naye n'okutuusa olwaleero myaka 5 okuva kwolwo teri muntu gwe baali bavunaanye oba ebintu ebyo tebyali bisimbiddwako mu kkooti yonna nti bizibiti. N'olwekyo tulowooza nti bikolwa just ekigendererwa tekyali kya kunoonyereza musango, kyali kya kumenya mateeka mu kyeyonoonere. No, Lorraine, don't let me preempt. But you can ask me that question 5 days from now. I'm sure the suit will be filed and I will share with you a copy. Not later than 5 days from now. By Wednesday next week, to be precise.
All right. Thank you so much, Council, for your elaborate discussion. You can proceed.
I now invite Advocate Jude Byabakama to come and take the podium to talk to us about the cases. He represents a ULS. Thank you.
Thank you very much, CEO. My name is Jude Byamukama. Byabakama is the judge, the chairperson of the Electoral Commission. Maybe I should change. I should say I did poll one of these days, because so many people continue calling me Byabakama, not Byamukama. MU. Like all of us are aware, Uganda Law Society has a couple of court cases, and some of them continue to generate a bit of public interest. The members are very interested. Before I came here, I was in a discussion with some of the members who are candidates for the Judicial Service Commission, and they wanted to know what's going on, what's the way forward, how is the Uganda Law Society performing, what's going on with the judge, the 3 rulings that His Lordship, the Honorable Justice Musa Sekana, delivered on the 14th of February, 2025. His Valentine's Day gift to Uganda Law Society. It's important to put them in perspective and what's going on. First of all, just to give some context regarding some of those issues which have a governance nature, Uganda Law Society is governed by an Act of Parliament, which is now known as the Uganda Law Society Act, Chapter 305, Laws of Uganda. That law was enacted in 1956. It was enacted in 1956. And it's important to always remember that. So many things have changed. This is a law that was enacted in the colonial times. And it's clear that there are so many aspects in that Act of Parliament that require amendment. One of the most obvious, on which everybody can agree, the criteria, for example, for calling for an extraordinary general meeting, it sets a threshold of 15 members. And yet, right now, as we speak, Uganda Law Society has over 5,000 members. The Vice President was participating in an enrollment exercise, which is welcoming another 100 today, maybe another 100 tomorrow. And yet, the law is saying 15 members, that's not even 2%, not even 0.5%, should be able to cause a general meeting of Uganda Law Society. This is 1956 when it was enacted. I wonder how many lawyers were in Uganda then. I don't think there were more than 60. And this has never been changed. So it is the law that Uganda Law Society follows. However, starting at the beginning of last year in February, there was a High Court decision in Brian Chirima versus Uganda Law Society, where His Lordship, the Honorable Justice Musa Sekana, issued an injunction prohibiting council from conducting meetings based on petitions by members until disposal of the main judicial review. That main judicial review has never been disposed of up to today. It's now 1 year later. And therefore, it imposes a limit on the right of members to requisition for extraordinary general meetings. Because of that, Council took the view that there was a need to seek an appellate review of that ruling, and that is one of the matters that's now pending, that we are seeking a position on that ruling from the Court of Appeal, especially since it now appears that the substantive ruling might not see the light of day in the near future. And then most importantly, we had two court cases. One was touching one member, that is Advocate Mujisha Hashim, sued Law Society, complaining about the suspension of our secretary, then Mr. Philip Munabi, and also complaining about some documents which Mr. Philip Munabi had circulated, dismissing the president and the vice president, among others. And then a ruling was made by the High Court, a ruling that the suspension of Philip Munabi was unlawful. The document he issued dismissing the president and the vice president was unlawful. And also ruling that council had no powers to suspend a fellow member of council, a number of rulings, but which continue to cause some level of paralysis in the manner in which Law Society operates, especially in view of the fact that Law Society is trying to operate under the framework of a law that was enacted in 1956 and that did not envisage some of these internal contradictions that Law Society is faced with at the moment. The second ruling concerned a candidate, Advocate Fiona Wall, who was challenging her disqualification from contesting for Judicial Service Commission. She felt it had been done unlawfully. The position of the Elections Committee being that she was not eligible to contest because she did not have 15 years standing to be eligible to represent Uganda Law Society to the Judicial Service Commission. The Judicial Service Commission is the body that interviews, vets, and disciplines judicial officers in this country. And therefore, it is only natural that Uganda Law Society under the Constitution is entitled to have 2 representatives to the Judicial Service Commission. Although the overall appointment authority, the formula in Article 146 of the Constitution is through the head of state. That election was meant to take place last year, and it was injuncted by an order of the High Court issued by the Honorable Justice Musa Sekana. And at that time, we did file appeals against that order. And unfortunately, before the appeals could be heard, Justice Musa Sekana delivered his final decision on the 14th of February. Although in Brian Chirima, for 1 year, no decision has ever been delivered, I must remind you. So it appears our courts can be fast when they want to. And therefore, because of that, our applications and appeals on the temporary injunctions were more or less rendered moot and academic. We would, as a lawyer, would have wished to get the Court of Appeal to pronounce itself still on whether those injunctions were lawfully granted, at least for the purpose of the public record. Unfortunately, courts of law in this country and generally have adopted a principle of legal mootness, that when there is no live dispute, the matter dies a natural death. So, Law Society's matters at the level of appealing against the injunctions have more or less died a natural death. Obviously, it's unfortunate that this should be happening, when we have judges who should hear matters in time. But it's not only a law society which suffers that. We have people in prison who serve sentences before the appeals are heard by the Court of Appeal, by the Supreme Court. And sometimes even by the High Court, someone is convicted by a magistrate's court. And by the time the High Court is supposed to hear the appeal 2 years later, he has served the sentence and gone home. And therefore, I think it's important for the judiciary to try to play its role to make sure everybody gets their fair day in court. And some of these frustrations are why some of our individual members of society might express their frustration in ways that are unconventional and unusual. But it's a big frustration that I should file a case in time, do all my filings in time, but I can't be heard. We filed when His Lordship, the Honorable Justice Musa Sekana, delivered his rulings, issuing injunctions some 2-3 days before the Christmas day last year, before 25th December. I filed substantive appeals within 1.5 weeks after that. I filed substantive appeals, I filed formal applications. Some of them I believe can be, thankfully these days we have electronic filings, so they are almost a public record which can be accessed. And then we cannot get a judge to hear us until around last week on Tuesday. And this is the fate of many matters, especially in the appellate courts. In the Court of Appeal, in the Supreme Court, many matters do not get heard in time. By the time the courts are hearing appeals, everybody has moved on because the appeals have been rendered irrelevant to their lives. So it's a big challenge that has to be placed in its proper context, because members of the judiciary come from among us. They come from law society, whether they are, some of them are active members, some may not be active members, but I think it's a challenge that members have to understand and confront. In regard to the final decisions that were delivered by the Honorable Judge on the 14th of February, we have since filed appeals in the matters touching Uganda Law Society. The Honorable Justice delivered 3 rulings, but the rulings which are particular to Uganda Law Society as an institution are 2. And therefore, we are addressing those 2 appeals. The matters touching the President, Mr. Isaac Semakade, he handles them in his individual capacity. The matters touching Uganda Law Society are what are handled in an institutional capacity. And they are the matters I address about. We have filed 2 appeals, that is civil appeals number 98 and 99 of 2025. I have already filed the substantive appeals. In fact, even if the Court of Appeal just said, come on Monday, we urge these appeals, I would be good to go. But well, I do not know whether they are again going to suffer the fate of being delayed and rendered meaningless, but I think everybody, the Council of Uganda Law Society, Mr. Philip Munabi, whoever filed all these matters, we all deserve to be given a fair hearing. Council deserves to be heard. Mr. Munabi deserves his day in court. We need to get closure of these internal governance issues. We don't have a framework that gives better guidance. The High Court is saying members of council cannot suspend a fellow member of council pending a General Assembly. But the High Court is saying the General Assembly is the one which has those powers. So who convenes the General Assembly? If the High Court says only a secretary can convene a General Assembly, so can a secretary convene a General Assembly to suspend him? So there are those sorts of issues. So for me, these are teething issues that are not about any individual. They are institutional. Obviously, the long-term solution lies in seeking to have amendments to the Uganda Law Society Act to address some of these recent challenges, but also it's a governance framework that's quite old. The same applies to the positions we have about the Attorney General and the Solicitor General. Uganda Law Society over the years has had litigation against the Attorney General on behalf of the public. But actually the Attorney General in the Act, is supposed to be a member of council. So we are imagining council is supposed to sit to discuss how to sue its Attorney General and Solicitor General. It's a framework that was made in 1956. And therefore, it poses significant challenges. And you have a judgment of the High Court saying, council, you should all be there and sit and decide. If we are going to sue the Attorney General should be called and he sits in the meeting and he decides whether we should sue him or not. And that the Attorney General under Article 119 is sued in a representative capacity of government institutions. It's a challenging situation. And so when we see these matters before the courts of law, it's important that we put them in their right perspective, because these are issues which nobody had wanted to raise and have resolved one way or the other, but we think the time has come for these matters to be resolved one way or the other. If we are able to get amendments through Parliament, that would be a better solution. So we clarify who does what. Today I was in a meeting, the Elections Committee of Uganda Law Society. That is an independent organ, by the way. It's independent from council. The Elections Committee, which supervises the elections, is not appointed by council as a small committee. They have independence once they are appointed. For example, the committee that exists now was appointed by the previous council, not the current council. And whatever decisions it takes, however, it's council and Uganda Law Society to deal with them. So when candidate Fiona Wall takes Uganda Law Society to court, it's about the work of the Elections Committee of Uganda Law Society, which makes decisions in which council is not allowed to have any input. They make their decisions independently. And so that poses a bit of a challenge. But again, I need to give you some history. The regulations governing elections of Uganda Law Society were enacted after an acrimonious annual general meeting. Those regulations only came into force because people went to court, people protested how we used to vote for leaders back in the day. And therefore, nobody should be worried about the current litigation involving Uganda Law Society. I believe it will result into, no matter how it ends, it has shown us some teething problems that need to be addressed. We shall continue to implore the judiciary to handle these matters in a timely manner, no matter how they end. No matter how they end. We will make our case, the judges will have their say, and that's about it. But what's important is to get these matters out of the way, because they give guidance to how Uganda Law Society, as a bar association, should operate. It's unfortunate that these governance issues may temporarily distract from the broader objectives of Uganda Law Society. As you can see, we live in very unprecedented times, so many challenges about the rule of law, about human rights, about independence of the judiciary, about the manner in which the judges are appointed. We have so many serious issues we should be focusing on. But unfortunately, in our house as well, we need to clean up before we can go out there and also assist the public. Because you never know. Maybe some members of our house prefer that we don't go out there and assist the public, so they keep us busy internally. But I think all of us, all members of Uganda Law Society, benefit from having respect for the rule of law. We all benefit from having an independent judiciary. We all benefit from having a transparent, fair, and accountable process in which all judicial officers are appointed, whether they be magistrates grade 1 or justices of the Supreme Court. That process benefits everyone. Unfortunately, Uganda Law Society is currently unrepresented at the Judicial Service Commission because of these internal differences that need to be resolved as quickly as possible. On the side of litigation, on the side of handling them in the courts of law, our appeals are filed and all necessary paperwork is in, and we'll we look forward to Uganda Law Society having its day in court as soon as possible, so we can get rid of this governance issue and we move forward. If the High Court of Appeal says yes, the secretary is the de facto president. He can decide the agenda and he can choose when to have a meeting. So be it. We move forward. We move forward. If the justices decide that, yeah, although one candidate has no 15 years standing, she must participate in the election despite Article 146, so be it. That's what we have. We shall deal with what we have, but it will be a lesson to us to learn what needs to change in how affairs are run. And therefore, we regret, especially to the candidates who have been campaigning to join the Judicial Service Commission, we regret that it does appear that that election is not happening as quickly as everybody thought it would happen. Because of these internal governance contradictions that remain. Speaking as an advocate for Uganda Law Society, I will also emphasize that the door to reconciliation and mediation of some of these disputes has never been closed. We look forward to being able to talk to each other and reaching solutions where we are able to, but also that does not compromise anybody's right to pursue the court process to its logical conclusion. And therefore, even Law Society, we have our appeals, civil appeals number 98 and 99 of 2025, which all touch on these issues of the judicial service elections and whether Advocate Fiona Wall should be a candidate or not, which touch the governance questions in light of the rulings of His Lordship, Justice Musa Sekana. These are questions that will be resolved one way or the other, and the earlier it is done, I think it will benefit everybody when it is done in a summary way, so we can all move on and focus on the broader objective of assisting the public in administration of justice. I thank you very much, and I look forward to your questions.
Thank you very much for that nice presentation, Mr. Jude Byabakama. I've had that presentation. Sorry, Mr. Jude Byabakama. I've heard that severally. Every time we've met at court, you've almost said the same words. But just one thing. The same courts that you're saying are not giving us a solution to the impasse at Uganda Law Society. You have already put there 5 appeals. You get it? Which you cannot determine when they will be heard. Even if you did, you cannot determine what the decision will be. But the issue is, you know in your head that there is a problem here. We need to find a solution here. You get it? You are standing on the inside, looking in the inside. If you put your eyes there and look outside, don't you think there's a solution? If there's a solution outside court, can't you explore that? I leave that to you. Thank you.
Okay, thanks.
Thank you. Counsel?
Mine, Jude, for me, is to get your opinion on whether it's not time to explore an amendment to the Advocates Act. And we are gifted now that Parliament has a number of members of ULS. Almost every party in Parliament, including Gemma, which has 1 MP, is a member of ULS. So, isn't it time to explore for either ULS as a group or people who believe to lobby 1 or 2 of some of our members to explore a private members, an advocate's amendment bill? Because if we are to look to AG, it may not come because of the heavy load that they have on their plates. For some other issues, not necessarily this, but issues like NEGM, the issue of who should be on the council, issues of who convenes 15 members, getting 15 members out of 5,000 is, so isn't it time to explore the amendment in your opinion?
Thank you so much. Any more questions? Council,
Maybe I need to first answer this.
you first take those ones?
Yeah, I'm not
Okay.
writing any notes.
It's okay.
I may overestimate my ability to remember them.
It's okay, Council.
Now, starting, I see Mr. Munabi has moved out. So anyway, I hope he's logged in, or you tell him. Yes.
I have a feeling he knows the answer.
Because it is true that I have had lengthy discussions with Mr. Munabi, and we have points of agreement and points of departure. He's a member of Uganda Law Society, and for us members, especially me as a lawyer for Uganda Law Society, I'm accountable to all the members. So as much as possible, I'm instructed by a council, but we try to be as accountable to everyone. And therefore, I have emphasized to him that the door of reconciliation is not closed, but it must be principled reconciliation. We have points of agreement. I do not think the courts of law may not give us a final solution, for sure. Because some of these contradictions arise because we are trying to fit a bar association with 5,000 members into a framework that was enacted in 1956. So it's only natural that there will be some difficulties that we continue to see. That is one. And yes, I think it's important for members of council and for everyone for us to continue to engage with each other as members to see if we can get a fair and principled resolution of these disputes internally. That is what everybody looks forward to, and it's what I look forward to. Yes, we have filed 5 appeals, but 2 of those appeals have been rendered moot because they were appeals against temporary injunctions. And now the final decision came, so those 2 appeals have fallen by the wayside. But it's also important for the public record to be clear that yes, when this decision was taken, the Bar Association was not satisfied. It filed an appeal. The appeal was not heard because the judiciary decided it had other priorities. That's beyond our control. What's within our control, we must do. What is beyond us, we cannot do. That is also the political reality of rule of law in this country. So I have always been telling Mr. George Musisinti, yes, you must challenge all these actions before the courts of law because that's in your control. What is not in your control is how the courts are going to determine these matters. But also, it is a learning lesson. When we learn that maybe judges are uncomfortable delivering certain difficult decisions, then tomorrow we learn that, oh, maybe when Judicial Service Commission is choosing judicial officers, we need to ensure that people who are too timid to make difficult decisions do not make the cut. We have to think long term about some of these matters because the judiciary will still be there in 100 years, in 50 years, in 10 years. And even the law society will still be there as well. So we have to make our effort to change certain things. And yes, so it's important to have principled engagements across the board where there are disagreements. What is not acceptable is for members to operate outside the ambit of the law. And therefore, Mr. Philip Munabi, who is one of the parties in one of the appeals, because the High Court ruled that he should be reinstated as secretary, and then a few days later he starts issuing documents without consulting counsel, yet the High Court was ruling that he cannot act without consulting counsel. It causes a very unnecessary friction that could be avoided by principled engagement. And therefore members must learn that principled engagement is what the law society strives for. And though these matters are in the courts of law, and we look forward to them being heard as quickly as possible, the door to mediation and trying to get a reasoned agreement is not closed. We remain open to all possibilities so we can have our house in order. But what happens if your child will not listen to you? Then turning to, yes, definitely, we need to seek to have amendments introduced to the Uganda Law Society Act, to the Advocates Act. I believe this is a process that we must continue to encourage, and our members who sit in Parliament, just addressing you, honorable members of Parliament, there is an acute need to seek a private members bill and help us. Let's make amendments to the Uganda Law Society Act. We need the Uganda Law Society Act to create an independent bar association that meets global standards. A bar association, an association of lawyers, by nature is supposed to be independent of the state and the other state organs. Independent does not mean hostile to the state. Independent means we should be able to run our affairs as lawyers without undue interference of the state. And therefore, it is obviously problematic when some officials of the state are conscripted by law into the leadership of the bar association. It's problematic and it's something that needs to be addressed. Similarly, some of these governance issues can be best addressed through amendments to the law. And so we look forward to many members of parliament combining efforts to support the bar association to improve its governance so we can address some of these internal contradictions and be better servants of the common good in terms of administration of justice. The purpose of Uganda Law Society is to support the public in administration of justice. The purpose of Uganda Law Society is not to fight for positions among ourselves as members. We exist to serve and support the public. And therefore, all these actions which distract from that noble goal are not helpful, and the earlier we can get them resolved, the better.
Thank you. There was one more question, if it's okay.
Okay, my question is, as all is going on, because at this very moment, the secretary was reinstated and the thing has not yet been formally or whatever challenged. So how are you going to handle this during the time when, until you get the government, and now, because yeah, definitely he came because he knows he's supposed to be here. How are you handling that challenge?
Okay, I don't think that is a challenge as such. The appellate process is ongoing, and we'll see what happens in the coming days. It's too early to determine. We will continue to have principled engagements with him, especially if he does not engage in erratic behavior, like we have seen a few days ago. There must be goodwill from both sides. I continue to encourage majority members of council to exhibit goodwill and humility in engaging. We had a consent to sign off last year before the ruling of His Lordship Sekana. We had reached some sort of agreement, and he walked away from it for unknown reasons. He accepted it when we were at court premises, and then he said he would sign it 2 hours later, and 2 hours later he didn't sign it. So we are determined to try to resolve these matters internally as much as possible. We will continue to make efforts. Where we are unable to, we will wait on the courts of law. And definitely as law society, we shall respect every court order we get. We will respect and implement. But when we are still pursuing an appellate process, it's important that we respect it and get guidance from the appellate court on what to do. The appellate court will give us guidance very soon. I believe not more than 2 months from now.
Thank you. Thank you so much.
Yes.
Council Mariam, come for a picture moment with the co-counsel.
Good afternoon, ladies and gentlemen. My name is Nas Samariam. I work with Uganda Law Society as a co-counsel to Counsel George.
I think you're going to do the edit. Pardon? Who is the edit? Yeah, it's
okay. Before Advocate Musisi took his seat, there's a question that came in from Senior Counsel Kunya. So I'll request him to come back here and maybe respond to that question.
Thank you, Madam CEO. our senior colleague, Councillor Henry Kunya, asked that I've just read on social media a chat from Afande College that office administrators of NUP were present. What is your take? Well, my take is that is a falsehood. It's inaccurate. We should remember that two premises were raided that evening, on Friday evening. The School of Leadership at Kamocha has an administrator called Doreen Kaija. She was not at the premises. Secondly, the party offices, the head offices, as far as you know them, there is no person called an administrator. The main administrator is the Secretary General, who incidentally was at the premises up to around 4 p.m. of that day, and he drove away in full presence of the people. He was not stopped, neither was he consulted or told. The only person, and of course the external security were chased away, and there's an internal security guard who sleeps at the premises, who was handcuffed, and throughout the time of their stay was detained away somewhere. That's the very reason why doors were broken. Otherwise, if there was an administrator, the person would have had the keys. So it's inaccurate that there was any person who was taking these people at any of the premises. It's inaccurate. Thank you. Waliwo abadde abuziza ekibuuzo nti balabye omwogezi w'amagye ng'agamba nti waliwo omukozi wa NUP gwayisa administrator oba ba administrator abaaliwo. Ekyo si kituufu. Kamocha essomero lirina administrator, Doreen teyaliwo era bamenya bumenyi. Administrator omukulu ku offices enkulu Kavule ye ssaabawandiisi w'ekibiina ye main administrator, era yaliwo ku olwo n'afuluma nga teri amukoonyeeko. Tewaliwo muntu mulala yenna ku lwa NUP yaliwo mweki bayita search. Omuntu nga bamaze okugobawo abakuumi abawabweru, waliwo omukuumi asulamu munda era nga yasibibwa, era ekiseera kyonna bwe kyaliwo nga ali ku mpingu era nga aggaliddwa ewantu. Y'ensonga lwaki walaba nga enzigimenye, kubanga omuntu yali abatwala yandibadde abaggulira bugulizi, badde tebeetaaga kumenya. Naye nga si kituufu nti waliwo omuntu nga bwe kirina okubeera. Nowa LC1 asaana okubeerawo mu search naye byonna tebyaliwo. So kituufu nti bakola nga waliwo omuntu gwe batambula naye.
Thank you so much, Council Musisi. A1, I'm the only one who knows that name. Yeah, at this moment, let's see your take over.
I'm sorry to bring back Advocate Musisi here, but I request for a picture amendment with head rule of law. They are big organizers of the Radical New Bar every Thursday.
Who am I to say to you? Where is Adam? If he has taken a picture of me and come and take a picture, don't come with a microphone.
Yes, Council, there is this special person coming to also have a picture. Let me pay the date.
I now invite our treasurer to come and speak to us. You're welcome.
Good afternoon, ladies and gentlemen. I send greetings from the President of Uganda Law Society. I thank Council Musisi for showing up at Uganda Law Society and being part of this fruitful engagement. And I also thank each and every member who has managed to attend this session physically and all members online. These are my comments as the Treasurer. I call upon members of Uganda Law Society to be patriotic about the society. Because why I say this is because that at the end of the day, or at the beginning of the day, we are all members of Uganda Law Society. When we go to school and we study law from all the universities that we normally go to, the most important objective is to be part of Uganda Law Society. And it is from there that we either become judicial officers, we either become state attorneys, name it all. So, our mother unit is Uganda Law Society. And the only way we can grow Uganda Law Society is if we love the society. We should work together as lawyers. If we backstab, if we fight each other, this gives way to other entities, other forces that may be happy to see the downfall of the society. We are all as strong as the society. Most of the members here, Councillor Jude and Councillor Musisi, have talked about the issue of a speedy trial. Most of the litigants, most of the lawyers have one problem. They have one query, that why should I file a case and get judgment in 10 years? Why should I file a case and get judgment after 5 years? Does this really serve justice? This goes to the judicial officers. You are our colleagues. The only difference is that now you have shifted and now you are working with the judiciary. Let's have a speedy trial over matters that are preferred or that are sent to court. The reason as to why people go to court is because they have failed to reconcile. Why should I take my brother to court if I can reconcile with my brother? Let's have a speedy trial. During the new law year of 2025, the head of the judiciary, Chief Justice, was very clear. And he said, if I may quote, that the doors, the windows are open. Uganda Law Society, the doors and windows are open. Through the Vice President of Uganda Law Society, we have written several correspondences to your office requesting that we can always have a discussion around whatever is happening. The judiciary, through the Chief Justice, is the father of the legal fraternity. The Chief Justice is the father of the legal fraternity. And then everyone follows. We pray that you look into your busy schedule and reconsider. The Attorney General, majority of lawyers have been saying, and I also say, that we have a law that is colonial. We have a law that began in 1956. We have a law that was catering for not more than 100 lawyers. Today, Vice President was in an enrollment process at the High Court, where I'm reliably informed there are more than 100 lawyers who are enrolling. We should have a discussion about breathing life in the act. We should breathe life in this act. The law should grow. Why should we stay behind? Why should we really stay behind over something that can be changed? Lawyers say, and lawyers asking, where is the CLE calendar? Lawyers online and lawyers present, I want to assure you that the calendar has been approved by Law Council, and we shall be communicating formally through our avenues the approved calendar. This is the calendar that enhances that enhances our legal abilities. Law is a learning process, and we can only learn through the various sessions that are organized by Uganda Law Society and our sister agencies. So I call upon lawyers to be calm over the issue of calendars because it has been formally approved. As the treasurer, my mandate is to supersede the administrative and financial capabilities of Uganda Law Society. Last time I mentioned, and I still mention, that Uganda Law Society is big because there are unseen faces. There are unseen faces who do the day-to-day running of the society. The society has what we call a secretariat, and it is fully fledged from the CEO up to the very last man or woman standing. They do the day-to-day running of this society. As council, we provide policy. On behalf of council, I'd like to thank the Secretariat for the good job they have always done. And we want to continue giving you our assurance that we are very much interested in your welfare, in your working conditions. And that is why, together working with the Secretariat, we are going to launch our library. For those members who normally, make applications for PCs, I think you see there is a charge of 50,000 to access the High Court Library. It's 50,000. Of course, it is optional. You may decide not to pay. But if you want to access the library of High Court, you have to pay 50,000 Uganda shillings. We are saying, as Uganda Law Society, that we are going to put in place our library that is free to all members of Uganda Law Society at no cost. We shall equip it with the best books, with everything that can enable a lawyer do adequate research. I also further promised that I will be giving an update about the financial capacity of ULS. When I was standing as secretary, as a treasurer at Uganda Law Society, one of the biggest issues that lawyers have is bombarding. You bombard them with a document, what we call a financial report. On the very last day, when they are having an AGM, let's say tomorrow, in fact, they send it on the day for pre-AGM, when you're supposed to probably debate on it the following day. So that has been an issue that we should always be transparent. We should always send timely updates. As you all know, the last time we had an AGM in 2024, it cost Uganda Law Society a leg, an arm, a head, because we had to pay 560 million. That was the amount of money we had to pay. That was the bill that was never paid. In fact, previous council paid half of that bill. And as the radical new bar, we inherited that bill among other bills. But I would like to proudly say that we have secured a partial payment of the balance. I think that is good news to the members. That's good news to the members. And we shall also pay that other balance that will be remaining. So that and many others I will be updating in the course of my other engagements that I will be having as we proceed. But I would take this opportunity to thank each and every member of Uganda Law Society that is actively participating in this session, and also the members that are physically present here, the media, and everyone. I may not be in a position to spot each and every person, but thank you for being present. That is my update.
I now invite the Vice President to take up the podium.
Thank you, Madam CEO. The Treasurer who has just been up here, the CEO, our guests for today, Council Jude Byamukama, who is also our council, ULS council, George Musisi, my good friend and a colleague. Thank you very much for sparing time to come and speak to the members today about the various issues. As you're aware, we launched this Rnblive weekly update for purposes of connecting with the membership and other members of the public to remain relevant so that people do not question what we are doing, what is council doing, but we speak to the people. And also in the area of promotion or promoting rule of law, we keep discussing pertinent issues at a time, issues that are affecting the area of rule of law and justice at a time. That is why we thought this was one of those avenues we should have that. So I thank my colleagues, Judge Mrs. for clearly elaborating the issues. We've been seeing these things in the media, but when we have one of our own elaborating and answering questions, it gives hope to the members of the public out there who believe ULS should serve them, who believe ULS has a duty to fight for them. And that's what we do. That's what we shall keep fighting for. Now, if you notice from Council Jude's presentation, he gave us the status, the current status, beginning with an outcry from the candidates. One thing I believe everyone knows is that this whole aspect of having members or representatives to the Judicial Service Commission go through an election came through the Radical New Buzz policy of democratization. It has never happened. This is the very first time. And just as we expected, of course it would face backlash. The members or the representatives of ULS at the Judicial Service Commission have always been selected by the sitting president. But as the Radical New Bar, we felt it is wrong. We needed to respect court's pronunciation, democracy, and the Constitution, and allow members of the bar to participate in selecting who should represent them because of the significance of Judicial Service Commission, because of the load of the work and the responsibility they are tasked with. Unfortunately, that process was put on hold. We were supposed to have this on the 17th of December last year, which we felt should have been a Christmas gift to all the members of the Uganda Law Society. Anyone who loves democracy, any member of Uganda Law Society should have been proud of that. Now, it so happened that that EOGM was stopped. We had some overzealous members of the society whom I would say probably do not have, the treasurer talked about members who should love their society, running to court to stop this process. And just like you also had the treasurer give updates, And just like we had Jude talk about the governance issues, how we manage issues as council, we had 3 major areas of discussion. As the society, we need to learn how to run our affairs without involving other people who do not need to go to court to help us or to guide us on how the society should be run. We should be independent. If we are saying we want to talk about the independence of the legal profession, we should depict that. We should be able to run our affairs, manage our affairs without involving outsiders or people to decide for us. And someone was asking, how did we get here? How did this all begin? You had council explaining, and of course, like we're saying, it's a governance issue. It started when we saw the elected secretary, Munabi Philip, issue erratic statements to the public that is dismissing the president and myself from council. And that is something we should be able to manage on our own. We don't even need to run to court to get a solution for that. And of course, as the majority of council, we sit and make a decision. We think this is something, because of that conduct, the membership with to whom we are accountable, because we are accountable to the members who voted us into office, should be the ones to handle this issue. Pending that, we felt as council, through a resolution, these erratic members, that is Munabi Philip then, and the central representative, should be suspended pending the EGM, where all these matters should be discussed. Members should be allowed, the membership should be allowed to participate in the governance issue. They should discuss that issue. So we felt we need to have an EGM to discuss that, the issue of governance and the behavior of some of us, members of council. The books of account, the treasurer is giving us piecemeals of how we found how the status of the society's books or finances, which should have been done at that time. And also the most important, the voting for the Judicial Service Commission, which all was put to a hold, like I said, by some members we feel do not have any love for the society, because that should have been the only solution. I still believe that EGM or the EOGM or a meeting of the members should have been the solution for whatever is happening, be it a governance issue, be it whatever. But that is how we ended up here. Now, I want to assure the members online, those who are here physically, that we do take our mandate very seriously. We don't sit in these offices to serve our own interests, but rather the interests of the membership. And we must take that with humility. We must do what we're supposed to do. Of course, pending or after the decision of court, you saw again other actions. Earlier today, I did issue a statement concerning that, the actions of some of the members. We all know that in the court's decision, Justice Sekana stressed that whichever decisions we should take, they should be taken as council. Even if the secretary is to call for a meeting, it should be in consultation of council. But then again, like Jude said, before we got to that point, we had tried avenues of, amicable settlement and having this out of the way for the benefit of the society and the good of the membership. Unfortunately, that wasn't done. And we still have the same members who still want to frustrate this process. That was the reason I chose to issue a formal statement, because members are asking so many questions. Members are asking questions, the answers are very limited. And I will go through that statement again briefly in, I'll paraphrase. This being our statement, the Uganda Society statement on the unlawful actions of Philip Munabi. He was around. It's unfortunate that he left. I felt probably this should have also been an opportunity to have an engagement, a proper engagement, because if our intentions are clear, then they should really be clear to serve the benefit of the society. So as Uganda Society, we strongly condemn the unlawful actions of Advocate Philip Munabi, who circulated a deceptive notice for an extraordinary council meeting on 24th February 2025 without consulting council members. This move is a clear contempt of the High Court decision in Miscellaneous Cause number 263 of 2024, which emphasizes that the Secretary's mandate is exercised in consultation with the Council. Munabi's actions are part of a larger pattern of behavior that led to his initial suspension from Council and a subsequent criminal complaint against him and his accomplices. We urge the Court of Appeal to expedite the hearing of our appeal to determine the legality of the Council's decision to suspend an errant member pending a decision of the General Assembly. We will continue to monitor the situation and take necessary steps to protect the interests of the ULS and its members. We advise members to remain calm and ignore Munabi's erratic behavior, as he will be held accountable eventually. If you notice, this notice, which was apparently addressed to us, council members individually, was circulated all over social media on a Saturday, purportedly calling for a council meeting on a Monday. We are all practicing advocates. We have work to do. But most important, the court was very clear. Even if we are to enforce, we say we respect court orders. We cannot, someone asked a question, we have to respect what court has ordered. But we also see this as contempt because it's outside what court ordered, what court directed. We believe this is aimed at creating confusion within the membership and creating a state of uncertainty. But I can assure you, I want to assure you that we shall not allow to be taken down that drain. We do serve the membership, we're accountable to the membership, and whatever we do is in the interest of the membership. Now, I also had questions about the president. Jude clearly stated the president has individual lawyers handling his matters, but we cannot again run off from the fact that events have happened that are also making us have so many questions. The members of the public, the members, Uganda Society members, asking so many questions. And as you're aware, before the happenings, before all this unfolded, the president had traveled out of the country on official duty. At the time he was in Kigali. Right now he's in Zanzibar attending the East Africa Law Society Council induction. And all this happened when he was out of the country. And I must say the happenings are so unfortunate. As you've seen, it is also a pattern which we've noticed since we took over office. It's a pattern that is absurd because we know the bar and the bench must work together for the good of the public, for the good of the country. We cannot work separately. One cannot fight the other because at the end of the day, it's the common person that suffers. Again, as the bar, we also, I'll stress what my colleague Jude stated, we must fight for the independence of the legal profession. All these laws, the ULS Act we talked about is an act of 1956. Everyone has talked about it. I think the time it came into force, there should have been around less than 100 lawyers. Right now, we're over 6,000. I've been presiding over an enrollment process today where 300 members are coming on board. Now, if we fail to have a proper way of resolving our affairs at this stage, if we cannot protect the independence of the legal profession at this stage, what will happen in the next few years when the members are 3 times the number we have? So as Uganda Law Society, we do condemn the actions, or what I would call the persecution of the president, Uganda Law Society, trying to send a message, because I believe this message is being sent out to all the members, not just one individual. This is a message that is being sent to all of us that we can handle, we can take care of you. We can manage you, we can punish you. And we believe it is affecting not just the image of Uganda Law Society, but also the image of the judiciary. Just, I think yesterday, I was reading a post by, a member of the public, someone who is who says they do not understand law. They are not very well educated. But by the time this person has noticed that there is a fight between the bar and the bench, and he's saying if judges and lawyers cannot resolve their disputes, how can we trust them with our disputes? And this lady says, I'm actually very worried. That's why I said the image it sends out there is very bad. We need to look inside our hearts and we resolve this, because it doesn't only portray the bar or the lawyers generally in a bad picture, but also the bench, because people look at us with hope that we are going to resolve their disputes. We are always preaching to them certain things like mediation, out of court settlement, and then they see us seemingly fighting, which is really absurd. And to that effect, I do have also our statement regarding the president, the status of the president. And this, it's titled, the Uganda Law Society condemns latest arrest warrant against President Isaac Semakade. And it is dated today, the 27th of February, 2025. The Uganda Law Society strongly condemns the Uganda Road Chief Magistrates Court decision to issue another arrest warrant against its president, Isaac Chimaze Semakade. This warrant, issued on Monday, 24th February 2025, is the second in less than 2 weeks, following a similar warrant issued by then High Court Judge Musa Sekana on 14th February 2025, which Jude called the Valentine's gift to the Uganda Law Society. We view these actions as a blatant abuse of judicial power and a continuation of the ongoing judicial harassment of our president. Despite the Uganda Road Court's awareness of the President Semakade's ongoing revision application in the High Court of Uganda, challenging an earlier ruling by the Chief Magistrate, Ronald Kaizi, the lower court chose to ignore these developments and still went ahead to issue a warrant of arrest. Like I said, the second one in less than 2 weeks. The ULS is deeply concerned that the judiciary is being used as a tool for persecution rather than upholding the rule of law and ensuring justice. We urge the High Court and Court of Appeal to expedite the hearing of our President's corrective actions and put an end to this blatant abuse of power. We call upon all stakeholders to join us in condemning this judicial harassment and to stand in solidarity with President Semakade and the ULS. Today, it is President. The next date could be you. The next date could be me. All we are saying is judicial power should be used to serve the interest of individuals and to promote the rule of law, but not to punish or to persecute individuals. That is our statement. I thank you all for listening to me, and thank you for coming once again.
I request our guests, Advocate Jude, Advocate Musisi, the Treasurer, to join the VP here for a picture, and also Head Rule of Law and Rule of Law Officer Gweni. Advocate Mariam as well.
And Gwen. Kale, ngenda kuyita mu bufunze kuba njogedde ebintu bingi, njogedde ku nsonga ezitukwatako nga Uganda Law Society, naye ngenda kukatiriza esembayo nti mwena mukimanyi nti wiiki ewedde oba sabiiti ewedde pulezidenti wa Uganda Law Society Ssemakadde waliwo ekibaluwa ekyayisibwa kibakuntumye nti akwatibwe atwalibwe mu kooti, nti ekintu ekyo tukivumirira ku lw'ensonga zino wamanga, nti twalaba nga kooti ya Buganda Road ey'omulamuzi Chief Magistrate yawaayo ekibaluwa ekyo kibakuntumye nga eragira nti President wa Uganda Law Society akwatibwe aleetebwe mu kooti, ate ng'ekyo kyali kibaluwa kyakubiri mu weeks 2 ng'otaddeko n'omulamuzi wa High Court Sekana kye yayisa nga 14 Ogwokubiri, nakyo kibaluwa kibakuntumye, nti mu kutunulira ensonga ezo tetugamba nti kino kikolebwa mu ngeri y'obutagoberera mateeka n'okutyobola eddembe ly'omuntu yenga ye nga Ssemakadde President waffe, nti mu kooti ya Buganda Road yakola ekintu kino ng'ekimanyi nti President yali yawakanya ensonga ezo mu kooti eddako eyawaggulu mu High Court ng'erinda nsala, naye era omulamuzi n'agenda mu maaso n'akibuusa amaaso oba okuba nti President alina yawakanyiza ensonga ezo okugenda mu maaso mu kooti ye, ensonga ziri mu High Court, ye n'agenda mu maaso ekyo n'atakifaako n'ayisa ekibaluwa ekyo. Nti nga Uganda Law Society tuli bennyamivu ku lw'engeri ekitongole ekiramuzi oba judiciary egezaako okukozesa amaanyi gaayo okulwanyisa omuntu ye nga Ssemakadde mu kifo ky'okukuliriza oba ekyokutambulira ku nfuga y'amateeka n'okukulaakulanya eddembe ly'obuntu. Era tusaba High Court ne Court of Appeal, tubasaba n'esekusaba okulabika nti ensonga eziri mu kooti eyawaggulu mu kooti ezo nga ziwakanya bino ebyakolebwa ogezaako okuzikolako mu budde, okuziyisa mu budde okukola ensala, okugezaako okuggyawo embeera eno eriwo gye tulimu. Nti era tuyita n'abantu bonna bekikwatako okuvumirira ebintu bwe bityo, okulabika nti teri muntu anyigirizibwa ye ng'omuntu nga oli akozesa buyinza bwe bw'alina mu ofiisi emuwerebwa omuwa omusolo okulwana entalo oba okubonereza omuntu ye nga ku lulwe ng'omuntu. So mu bufunze tugamba nti ebikolwa ebyo biraga nti yensonga lwaki n'omuntu wa bulijjo akitunulira nti waliwo okulwanagana wakati wa ekitongole ekiramuzi ne Uganda Law Society oba ekitongole ekifuga bannamateeka, kyetulowooza nti nsonga mbi nnyo oba si kya bwenkanya, si kirungi eri abantu, kuba omuntu wa bulijjo wanga atasobola tulabirako twandibadde kyakulabirako engeri gye tukwasaganyamu ensonga zaffe oba obuzibu bwe tulina, naye ate bwe kituuka ku mbeera eyo nti olwaleero President Ssemakadde nkyajja kuba muntu mulala, n'olwekyo tuvumirira enkola eyo, tusaba buli muntu yeekube ku mutima ogezaako okukola ekintu ekituufu naddala nga tutunuulidde okukuuma eddembe ly'omuntu n'okukuliriza ekyo wabula nga si kulwanyisa oba kubonereza kyekyo. Nti n'ekirala obuzibu bwe muze mulaba ebiseera ebisinga nti Uganda Law Society tulina etteeka eritufuga oba lyetugoberera nga lyakolebwa mu mwaka gwa 1956. Ndowooza mu mwaka ogwo balabe bayinza n'okuba nga baali tebawera balooya 100 naye essaawa eno tulina abalooya abasuka mu 600 n'olwaleero mbadde nva okuyingiza abalooya abapya abamaliza okusoma nga bayingira okutandika okukola bantu nga 3 nti omwaka gugenda okuggwako nga tuli mu balooya nga 100 naye bino byolaba n'ezenkana ze tulina nti etteeka eritufuga oba lyetugenderako tetujjaamu tuyinza kukwata abantu 600 n'obateeka mu tteeka eryakolebwa nga bantu bali 600 yensonga lwaki waliwo kye tuyita friction oba okusika omuguwa tulowooza batusaba nti kooti emisango egy'enjawulo Uganda Law Society gye yatwalayo eyise mu bwangu okutuwa ensala okulongoosa mu mbeera eyo naye te nga si n'ekyo tujja gezaako okupushinga okulabika nti mu palamenti etteeka eryo obuwaayiro obusinga buteekebwamu oba tufuna endongoosa okulongoosa mu tteeka eryo okulabika nti lijja oba nerituuka neriba nga lisobola okutambula n'embeera yakati embeera yakati oba embeera eriwo lwakuba nti tulabye nga obuzibu bwonna buviira ddala ku tteeka eryo eryakolebwa emyaka emikadde so tusaba era bekikwatako oba abatunuulidde nga yandibadde ng'alina obuvunaanyizibwa obwo okulabika nti bagezaako okwanguya ensonga ezo zandibadde nga zitereeza ensonga ezo kuba singa etteeka eryo teritereezebwa era tujja kusigala ng'obuzibu tubulina nga Uganda Law Society ekyandibadde ekitongole nga kiyimiriddewo kyokka nga wekiri nga kikola emirimu gyakyo mu kuwabula gavumenti mu kuwabula omuntu wa bulijjo nga teri akinyigiriza oba akiyimiridde ku mutwe so tulowooza nti kikulu nnyo okulongoosamu eri etteeka era tujagezaako okukisindika okulabika nti kikolebwa.